Okay. Um, Thank you. Thanks, Obi. That was very nice. My name's Dave McLane. I'm on the board of Exonerated Nation, and I'm a criminal defense attorney and a civil rights attorney, which is a little bit uncommon. I started off doing criminal defense in the Federal Public Defender's Office. I did that from 1990 to 2003, and I represented individuals charged with federal crimes. And then I left the federal public defender in 2003 and started my own law firm with a couple other attorneys. But we always had in our mind that we wanted to do civil rights in addition to criminal defense because we think it kind of goes hand in hand. Because when someone is wrongfully convicted and spends all those years in jail, the main thing is to get out of jail, to be exonerated. That's the most important thing. But when you get out, you think, well, it's not out of vengeance, but it's just out of justice. How do you remedy what happened to you in the past? How do you get back those years that you spent in jail for a crime that you didn't commit? You're never really going to get back those years, that lost time, because you learn as you sit in jail that time is more valuable than money. What you can do every day that you breathe and you wake up the next day, it's more valuable than all the money in the world. But you should be compensated. You should receive justice. And justice in our legal system is financial compensation. But it also can be a few other things, as I'll describe during this workshop, because I think and I'll turn to Obi a few times during this presentation, because I've worked with Obi since, I think it was 2011, since you got out. And we did a lot of things with Obi. It wasn't just about getting financial compensation. Obi had an idea that he wanted to help other exonerees. And I'm saying, well, yeah, Obi, let's take care of your case first, then we can talk about it. But he said, no, this is really important to me. So as soon as he did receive compensation, he started Exonerated Nation. And I think Exonerated Nation is a metaphor and also a vehicle where people can do more than just get financial compensation. They actually can change society and change the system, so wrongful convictions don't happen. So can you put up the slides, Gail? The first slide? This is a PowerPoint. Okay, so this is, this is just to help get through this presentation. It gives me something to work off of. But okay, you're exonerated, you're out of jail. So now what do you do with your life? And I think, and I remember this with Obi and other exonerees I worked with dealing with civil cases, is that they want to do it all at first. They want to get out in the world. They want to, and they speed themselves up. And what I would say to people is take a deep breath and think what you want to do with your life. And think about how you're going to remedy the injustice that was done to you. And you need to think about that. And you need to get connected with someone like Obi in Exonerated Nation, who can help guide you to, especially in the state of California, can help guide you as to things you can do to help your life and get back on your feet. But you also should consult with your habeas lawyers and talk about, well, is there some form of justice I can receive in the form of civil compensation? And that's what Obi did. His lawyers were the Northern California Innocence Project, and the Loyola Innocence Project, and they introduced OB to our firm, K. McLane, Benarski and Litt, and myself. And OB decided to pursue civil remedies. But can we go to the next slide, Gail? Celebrate, of course. OB's release. Okay, this is the day he was released in 2011, and he's really happy. He's there with Denise, and you can just see the look on his face of pure joy. It was terrific for Obi. So the next slide, Gail. This is what you do when you get released, especially in the state of California, but Obi is connected throughout the country. Call Obi if you've been released, and he can direct you to resources in the state where you are. He can also, what Exonerated Nation does, it helps connect you with resources that you can do, especially in the state of California, to get a little gate money and to get housing and other resources that can help you with your life, because that's the first thing you need to do. So next slide, Gail. So this is what Exonerated Nation has done. Obi's Law, AB 672, Obi's Law requires that the state provide a free driver's license or DMV identification card to exonerees, and that the California Department of Corrections and Rehabilitation is required to provide the same transitional services to an exoneree as they would do with a parolee, right? Because that was one of the main complaints with exonerees when they got out. Well, you were never convicted of a crime, so you're not on parole, so you know, the CDCR doesn't need to help you. Well, that was changed with Obi's Law. And then in 2018, SB 1050, also Obi changed things, and Exonerated Nation changed things in the state of California, that upon release, they immediately get $1,000 in gate money, enrollment in Medi-Cal for healthcare, and CalFresh programs to help with food. Okay, so, and that the CDCR is supposed to notify the Department of Justice in the state of California the exoneration, and the DOJ must immediately expunge the person's criminal history. Now, there's difficulties with that. I mean, the DOJ is slow to do it, and you really should get legal help or someone to advocate you to ensure that that expungement is done. But that's what SB 1050 was supposed to do in the state of California. And for people in other states, there may be laws in your state that are similar to this, but if not, what you should think about doing is calling your local legal aid, or there's probably a innocence project in your community that can help your community with getting these types of laws on the books, so you get the same sort of relief. Next slide, Gail. And then there's AB 701, exoneree housing. This is really significant, that upon your release, you get an immediate payment of $5,000 for housing expenses, and you also receive direct payments or reimbursement for reasonable housing costs for 4 years. So this is amazing. And through Exonerated Nation, a couple of people have already taken advantage of this and are receiving their housing costs. Because when you get out and you're on your own, or you don't have a friend or family to help you, and plus you might not want to burden your families or friends, and you want to stand on your own feet, this helps you to do it. And then this, AB 2003, I believe also a couple of exonerees have taken advantage of this too. Free community college, Cal State College, or University of California. Now, University of California tuition to go to a UC is $20,000 a year. California State College is $10,000 a year. This is significant. So for anyone who can get into Cal State College or University of California, and you might say to yourself, well, I can't do it. I've been in jail for all these years. You can get in. And in fact, these institutions love to have exonerees come to their colleges because they can tell their story and they can be an inspiration to other students. So this type of things can be done in other states, this type of legislation. And what Exonerated Nation has done is created a platform, or at least a base, that people can get on their feet, have some money, have access to programming, that they can do something with their lives. And Exonerated Nation does a lot of other things, but the focus of this convening is to talk about civil remedies and financial compensation. So now we're going to move to that. The next thing is a motion to expunge. This is under California Penal Code 851.8. Once you've had your, once you've been exonerated, and this also requires that you not have a pending civil case, so it has to actually be done after your civil case is completed. Under California Penal Code 851.8, a court can expunge your conviction and have your arrest records destroyed. And that the court order goes to like the California Department of Justice, and they're supposed to destroy all your arrest records. Because think about it, this is really important too, because let's say you're driving and you're speeding on the road. What does the police officer do? The first thing, they look up your criminal record. And if your arrest record hasn't been expunged, they'll see that, oh, you were arrested for homicide. Not a good thing in an encounter with a police officer to have that looked up and to have that hanging over your head. Well, there's something that you can do about it. And this is one of the tools that I think not a whole lot of exonerees have done, because it is, you probably need legal representation. You have to file a motion. You have to get a court order. And you have to prove that there was no reasonable cause to justify the arrest. When you file this sort of motion, the best way to proceed is to get the district attorney on board not to oppose the motion in the first place. Because if you can get them to stipulate or agree to the motion, then the judge will order it. If you have to litigate it, it gets a little more difficult, but it still can be done. Next slide, Gail. Okay, this is something that's very significant. I believe that most states have this. And when you get released, what you should do is consult with your habeas attorneys, and then have your habeas attorney get you in touch with people. Either the habeas attorney can handle the statutory compensation, or you can get a civil rights attorney to do it. In Obi's case, it was both our firm and the NCIP who handled his 4900 penal code claim, okay? And one of the changes in the law, there used to be a 2-year, after your exoneration in California, you used to have 2 years for that you had to file this 4900 claim. They've extended the statute of limitations to 10 years now. But I would say that it's one of the first things you want to do when you get out, is to file a 4900 claim, at least to get it on file. You don't have to have it decided, because there's a California Penal Code section 4900 claim. You might think, oh, I spent 10 years in jail, it compensates you at $140 a day now. In Obi's time, it was $100, but now it's $140 a day. So they've increased it, but it's not automatic. And there's a lot of strategic concerns that you have to consider when you do it. Now, next slide, Gail. There's 3 ways that you can get compensation under California Penal Code 4900. One of the things is, and this is for people who are still fighting their habeas, one of the things you can try, that your habeas attorney can do, And I know the priority is when you're incarcerated, the priority is to get out no matter what. Any way that you can get out, you should take it. But if it's clear, like through DNA evidence, or someone like a jailhouse informant who recants and there's no other evidence, or something that indicates you are clearly innocent, the judge handling your habeas should be willing to consider making a factual finding of innocence. And if that finding is made by the judge handling your habeas proceeding, that is binding on the Victims' Compensation Board. That happened in the Susan Mellon case. She's an exoneree in the state of California, and she won her habeas, got released, but at the same time, the judge said, you know what, you're innocent, made a factual finding. She took that finding, went to the Victims' Compensation Board, and got compensation right away, a lot faster than Obi did or other people who are fighting it, right? And that kind of money really can come in handy early, because when I get to talk about a civil rights suit, that takes years. It takes several years, unless you do a quick settlement, but quick settlements tend to come at a price, at a lower settlement price than if you litigate it, gather more evidence, and prove your civil rights case, which will raise the settlement value of your case, or if you have to go to trial. But now, the second way, under California Penal Code 4900, if your habeas court has not made a finding of factual innocence, you can file a motion. You can file a motion for factual finding of innocence with the court that granted the habeas. And that's also binding on the California Victims' Compensation Board. That's what we did in Obi's case. We thought, look, we went on the website for the California Victims' Compensation Board, and we looked at all their determinations. And something that became very clear, you either need to get the Attorney General to stipulate to innocence in the granting of your claim, or you need to file a motion and have that motion granted by the habeas judge who heard your habeas and exonerated you, and get a finding of factual innocence. And that is also binding on the California Victims' Compensation Board, okay? That's because what we found looking at the website is that if you didn't have such a finding by the judge, that would be binding on the board. And if the Attorney General didn't agree with you when you filed your 4900 claim, you're likely to be denied compensation, because if the Attorney General fights it, it's very difficult to win it, okay? So that's the second way. The third way is that you litigate it with the California Victims' Compensation Board. Next slide, Gail. So you request that the Victims' Compensation Board grant a factual finding of innocence. Now, the Attorney General may stipulate or oppose the request. And there was an exoneree that I represented on a 4900 claim, John Smith. And what we did is I convinced the Attorney General to listen to our case and to meet with John Smith and hear him out, and then decide whether they would stipulate or oppose it, because I knew that John Smith was innocent. And we also looked, in John Smith's case, we also evaluated that case as to whether we should proceed with the civil rights case in that case. And we decided that we couldn't, because, and I'll talk to you later about civil rights cases, but we didn't think that we could proceed with the civil rights case. So it was very important that we get 4900 compensation for John Smith, because that was going to be his only real avenue for compensation for all the years he spent in jail for a murder he didn't commit. So the Deputy Attorney General flew down to Los Angeles, met with myself and Mr. Smith. And Mr. Smith, once you heard him, you knew he was innocent. And she said after the meeting, says, I believe him, the Deputy Attorney General. And she recommended compensation, and he was compensated. Now, sometimes, most of the time, the Attorney General, unless you have dispositive DNA evidence or something to show that your client is innocent, because these are the same people that are fighting the habeas, right? They've been fighting the habeas in federal court or even state court and opposing your client's exoneration. So they're fighting it because they might believe that your client's still guilty, even though it's ridiculous. So you can have a hearing. And in another case, George Soliotis, we had an actual evidentiary hearing before the California Victims Compensation Board. It was like a trial. We were there for 2 days. We called witnesses. We called Mr. Soliotis. And at that hearing, you have to prove by a preponderance of the evidence either the crime with which the person was charged was either not committed at all, or if committed, was not committed by him or her. And that really fit George Soliotis' case because he was charged with committing an arson. He was a landlord, had a house that he rented to a family who had children, and there was a fire and they died, and he was charged with arson, convicted, and then exonerated. He was exonerated because the experts determined that there was no arson. It was just a fire. So under the standard, under California Penal Code 4900, there was no crime at all. Not only did he not commit it, but the crime wasn't committed at all. So he fit perfectly within the compensation scheme and should have been compensated. The hearing officer, after 2 days of hearing, wrote a 60-page opinion recommending compensation. We go up to Sacramento for the hearing on McLane. And in the 20-minute hearing, without consideration of any of the evidence we presented, the Victims' Compensation Board, because the Attorney General opposed it, denied compensation. It was a travesty of justice. It was a miscarriage of justice. I mean, I felt a sinking feeling in the pit of my stomach, and I felt so sorry for Mr. Soliotis because he's like he's in his late 70s now, and he's been waiting for compensation. We've been litigating his 4900 claim for, I don't know, it's been at least 5-6 years now. Right now, next slide, Gail. Oh, okay. Well, just to finish up, we filed a writ in Superior Court for Mr. Soliotis because you can appeal the Victims' Compensation Board determination, and that writ was granted in part by the Superior Court judge, saying that that the findings made by the Victims' Compensation Board were inadequate, didn't justify them contradicting the hearing officer's determination that Mr. Soliotis be granted compensation. But we're still litigating it because we felt that the writ should have just ordered that he be compensated. So we're still finding it out. And an interesting twist in that case is that the Attorney General now supports compensation for Mr. Soliotis. We have an actual letter from them supporting it that's gone to the Victims' Compensation Board, and the Victims' Compensation Board still does not want to give him compensation now. So amazing, right? Amazing. We're still fighting it though, and we think eventually we'll succeed. So that is the California Penal Code 4900 scheme. And for you people out of state, you might have that sort of statutory scheme in your states, and you should look at it. I believe Texas has something like this. And you know, one thing to recall, one thing to remember is that even though you get compensated through OBs, through the things that Exonerated Nation has done, or you get compensated by the Victims' Compensation Board, that doesn't take away from any compensation that you can achieve or obtain through a civil rights lawsuit, okay? So there's several buckets or pockets you should look into when you're thinking about being compensated for your years in prison. Now I'm going to talk about civil rights cases. And the main statute that we file under when we file, and we like to file in federal court versus state court, but because the state courts, the judges tend to be deferential to the local police and the local law enforcement agencies and their elected officials, whereas federal judges are appointed for life. They have no political pressure. Now, it is kind of a crapshoot. You can get a good federal judge or a bad federal judge, and you're kind of stuck with them. But in the main, we believe it's far superior to file your civil rights lawsuit in federal court. And the statute that you use to file a federal civil rights lawsuit for a wrongful conviction to allege that your civil rights have been denied is 42 U.S.C. 1983. That statute was enacted at the time of the Civil War, post-Civil War, and it was mainly to remedy issues relating to slavery and the civil rights of slaves being denied. But over the years, it has now, starting in probably the 1970s, it started to be used in the wrongful conviction context. People started saying, wait, whose civil rights have been denied more than someone who sat in jail for a crime they didn't commit? Now, the thing that you got to remember, that there are differences between the habeas and a civil rights lawsuit. And I'm sure Obi could vouch for that. Because in the habeas, there are several ways to get out. You can get out by proving your innocence. And you don't need to show any prosecutorial misconduct or police misconduct or ineffective assistance of counsel. Or you can get out by showing one of those other three things: prosecutorial misconduct, police misconduct, or ineffective assistance of counsel. Now, if what happened to you was the fault of your lawyer and had nothing to do with the police, then you really don't necessarily have a civil rights lawsuit, because a civil rights lawsuit is accusing people acting under the color of law. That means the police acting under color of law who have deprived you of your civil rights, okay? So if it's your lawyer, he's not the state, okay? And I'll talk a little bit about legal malpractice actions in a second, but that's one way. Don't switch sides yet, Gail. But one of the things that you really need to think about immediately when you get out is contact your habeas attorney, have them refer you to a civil rights attorney. Now, there are a lot of sharks out there who will just call you out of the blue. I'm sure that happened to you, Obi, because there's usually publicity surrounding the release of an exoneree who spent many years in jail. And they start cold calling the exoneree and say, hey, I'll represent you, sign up with you. That's not a good move. You should work with your habeas attorney who can find you or refer you to several reputable civil rights attorneys who have experience in this field. Now, and there are many, and I feel that our firm is competent in this area and can handle it, but there are other firms that are just as good. It's really more of whether it's a fit with you personally. Do you feel comfortable with that lawyer? And do they have the experience and the knowledge and the ability to handle your civil rights lawsuit? And so, but one of the first things to remember is the statute of limitations, okay? You have to remember that under federal civil rights law, you have to file your lawsuit within the time period after the statute of limitations begins to accrue. And that's generally the date. There's a Supreme Court case, Heck v. Humphrey. It's within, and the statute of limitations can vary from state to state because it's usually tied to the personal injury, time to file a personal injury lawsuit within your state. So if the personal injury lawsuit gives you, in your state, gives you 4 years, then you would have 4 years after your criminal case is dismissed. In California, it's 2 years. So you have 2 years after you received a favorable termination of your criminal case for which you've been exonerated. Now, and if you have any, one thing I forgot to say to everyone, if you have a question, just stop me and ask your question, okay? I'm more than happy to take questions during this presentation. And if you don't, and if you want me to repeat something or you want to discuss something, that's fine too. But I'll continue. So, so you have 2 years in the state of California, and that's used, and I have a case in Arizona right now. It's also 2 years in Arizona. So favorable termination, what's that? It could be the date on which you're exonerated by the habeas court judge, or more likely, it's the date that your actual charges are dismissed, because when your conviction's reversed, as you know, that's not necessarily the end of the case. They can try to retry you. And they give the state a certain amount of time to retry it. And then your habeas attorneys, and maybe a criminal defense attorney you've hired or has been appointed, tries to get the case dismissed. And that generally is when the statute of limitations accrues, okay? Now, I want to tell you something. If your claim is a false arrest, let's say you weren't wrongfully convicted. Let's say you were falsely arrested, you spent time in jail, but you were never tried and convicted of the crime. Your statute of limitations would start to accrue within 2 years of the false arrest. So your case could be pending for years, let's say, but if your theory is that you were falsely arrested, you would have had to file your lawsuit during the time that your criminal case is pending, okay? That's why we try to frame these cases generally as wrongful convictions, where the statute of limitations starts to accrue at the time of termination of your criminal case, dismissal after the habeas.
I have a question, Dave. I have a question now. Hypothetically, you have an individual that had been exonerated or that was released, and the district attorney sits on the case or refiling the case, and it's a fight, and that fight may go on. Say, for instance, it goes past the limitations that are set there for the Victims' Compensation Board, or it goes past. You have individuals who've been home for 8, 9 years that's still fighting. Question is that once that verdict comes down and they say, well, and they clear that individual, is that the time now? Do they press now, or do they need to be concerned about, well, wait, my limitations then ran out over here? Is there still a remedy? Should I move forward? What's the
Well, what Heck v. Humphrey was saying is basically, you can't file a civil rights lawsuit that would attack or impugn, is the word they use, the validity of your criminal conviction. So until your criminal conviction is vacated, your civil rights lawsuit is not ripe. And you really have to wait till your criminal conviction is vacated to file your civil rights lawsuit. And you have 2 years after that date in the state of California to file your civil rights lawsuit. Now, there's a caveat though. If you're filing state claims, you can file state claims for violation of the Bain Act, other state law claims, along with your civil rights case, which sometimes we do. In California, you have to file a government 910 claim within 6 months of termination of your criminal case. That moves it so you need to file that government claim 6 months after dismissal of your criminal charges if you want to preserve state law claims. Now, I've had people come to me, one of them, people have come to me in that 6 month period that has lapsed, and they say, well, can I do anything? I said, well, we can file a federal civil rights lawsuit because you have 2 years and you don't have to file a government claim for a federal civil rights lawsuit. So we still can file the federal claims. We just can't file the state claims. Okay. But those are these tricky sort of timing issues. That's why you need to, when you get out, consult with a civil rights attorney. Next slide, please.
Hey, David.
Sure, Ruben.
Could you file a federal stay in abeyance in the meantime to stop the federal time tolling while you deal with your state matters to preserve time limitations, or would that not be necessary?
You don't need to. You don't need to file anything as far as the civil rights is concerned. A stay in abeyance, that's more in the habeas context.
Yeah.
Where you need to exhaust all your claims, but your time ran out, your 1 year time period ran out to file a federal habeas corpus petition. And so what you do is you file your federal habeas petition, and then you file a motion to stay so you can go back into state court and exhaust. But that really doesn't apply in the civil rights context. But that's a good question.
Thank you.
So, now,
I've got a point.
Sure, Marvin.
During the course of the DNA testing in my case, I'm just showing that sometimes you need to file an abeyance because during that time, results of your DNA testing, you have 60 days to file your writ of actual innocence with the court. So we had a piece of evidence we were waiting to have tested after the last hearing, and we waited and we waited and we waited. So the judge finally called us back in and asked, is the DNA testing done? The state said, no, Your Honor, we've lost a piece of evidence, so we're not going to be able to test that. All right, they threw me back to the last hearing where they had gotten the results of the testing. When I tried to file an abeyance, the court said, no. You had 8 days to file it. You're dead.
Well, I'm sorry to hear that, Marvin, but that's true. When you have habeas proceedings, they have their own time deadlines that you really, that's why civil rights cases are so different than habeas cases. I would never do a habeas thing. I would contact, like in California, the Loyola Innocence Project or the Northern California Innocence Project, because they're experts in dealing with those sorts of issues. Now, one thing, I get this a lot from people, is because not only did the police violate their rights, they felt like the attorney who represented them trial wasn't very good. And sometimes the habeas petition was granted on ineffective assistance of counsel under the Strickland case, right? We all know that. And often judges on the habeas, they love to find that instead of making a finding that the police or the DA engaged in misconduct, right? The ineffective assistance, let's blame the defense attorney. But the problem with that is, and our interest is more is suing the police for misconduct by the state. I don't think I, frankly, have ever filed a legal malpractice case. But that is something to consider, but there are very strict statute of limitation time deadlines. And often it prevents you from pursuing a legal malpractice case because legal malpractice in California is within 4 years of the date of the wrongdoing or the date the client actually or should have discovered the wrongdoing plus 1 year, whichever is earliest. That's in California. So your case could be ongoing your underlying criminal case, and you're barred from filing a claim for legal malpractice against your lawyer. There is some tolling procedure, meaning that this lawsuit, legal malpractice case could be tolled for periods of time. It's like, as long as you have that same lawyer, you have a tolling period and you don't have to file a legal malpractice case. Or if the attorney conceals misconduct, that can toll the 4-year statute of limitations. Or if you have a legal or physical disability. Okay, so that can affect on malpractice. But generally, it's very difficult. Like when Obie Anthony came to us after he'd been exonerated, there was no possibility to file a legal malpractice case because the time had lapsed. And in most cases, for people spending years in jail fighting their habeas, they have a different attorney. It's very unlikely that they'll be able to file a legal malpractice action. The laws were written in a way to help attorneys writing laws to help attorneys. You can look at it that way. So let's go to the next slide.
Dave, as she's pulling that up, I have one follow-up question in respect to that. Like say for instance, in the case similar to Terry's, where, or even Rhinus that's been in Hawaii, where you have a person who's come home on parole, may have spent X amount of years on parole, but nevertheless still has been seeking opportunities, in other words, to receive, in other words, to get exonerated, to get their name back, right? And that may say they may have been on parole for 5, 8 years, and it takes another additional 5 more years before they get their actual exoneration or get that actual finding of factual innocence or actual innocence. Is that now does time at that point begins to start tolling against them in respect to filing, if they're in the state of California, a 4900 claim or a 1983?
Yes.
Does it start then?
Yes.
Nice.
Yes,
Okay.
because if you still have your criminal conviction, which they do because they're still on parole and they're still trying to get that exoneration, the statute of limitation doesn't begin or accrue until the criminal case is resolved. So even though you've served your whole sentence and are on parole, if you're still trying to get that conviction vacated, you still can file a civil rights lawsuit or a 4900 claim after that.
Nice.
Okay?
Thank
Does
you.
that make sense?
Yeah.
Okay.
Yeah. I mean, like I was having a little, in my mind, first thought in my mind about that portion of the population who's coming home on parole, spending some time on parole, and it's alleviating their opportunity, in other words, to file those complaints because they're still in that process. So, yes, they help. Thank you.
Now, I'm going to talk a little bit about the different types of claims you can file under a federal civil rights lawsuit. And that really is that's individual. It depends on the type of violation that you suffered. Okay, you have to tie what happened in your case. Did the police fabricate a jailhouse informant confession? Did they fabricate the defendant's confession? Did they coerce an eyewitness to make a false identification? Did a scientist in the DNA lab make up the DNA results to frame someone? And that happens. You shouldn't be surprised that there's lots of cases involving scientists who should be dedicated to finding out the truth who'll make up the results because they receive pressure either from the DA or the police to make up a lab result to implicate a defendant in a crime, and then they're found out. That's a claim. That's a civil rights claim because they're working for the police and they fabricate evidence. So there's different types of claims or concealing evidence. One of the most common things is concealing giglio, what we call impeachment evidence. That happened in Obie's case. Okay, so there's different types of claims you can make, and it depends on the type of wrong, what the police did to you. So The case, concealment of exculpatory evidence under Brady versus Maryland and Giglio versus United States. Those are cases that say if you conceal exculpatory or impeachment evidence, then that can be the police do this, that can be the basis for a civil rights claim. That happened in O.B. Anthony's case. There was this pimp who had an apartment building where he's running prostitutes out of. At the same time that Obie was charged with murder, this guy had a pending pimping and pandering case. He was looking at 13 years in state prison. Unbeknownst to Obie, he made a deal with the DA prosecuting him to get probation instead of the 13 years. And the probation report recommended he get the 13 years, okay? So he got a sweetheart deal to identify Obie as the perpetrator of the homicide, okay? That deal was denied by the DA in court. In his closing argument, he said there was no deal, that John Jones was a good citizen, and he was coming forward out of the goodness of his heart. And it was not true, because the paperwork was not, the DA, another DA made a deal with John Jones in his case, and that DA did not tell Obie Anthony's DA, okay? And the police facilitated that deal. The detective, Marcella Wynn, made that deal with the John Jones DA on his behalf so she could use John Jones in Obie's case. That was very significant because in Obie's case, why it was so damaging to Obie is that they portrayed John Jones as a good citizen who was just coming forward out of the goodness of his heart to identify Obie, when the truth of the matter is the guy was looking at 13 years hard time in state prison, and he would say or do anything to stay out of prison. So that type of concealment is the basis for a civil rights claim. We call it a Brady claim, we call it a Giglio claim. It's concealment of exculpatory evidence. Now, one of the things that I talked about, but you need to be clear on, and this is often in the habeas, to you, it doesn't matter whether it's the police or the DA that engages in the misconduct. But as Obie learned, and as in the civil rights context is very, very important. If the police, in your case, tell your DA that, for example, John Jones made a deal, then there isn't misconduct by the police. The misconduct was by the DA. Now that's good enough to get exonerated, but as what you all should know is that the DA has absolute immunity, okay? You can't sue an individual DA, so you're stuck. So in the situation, it's better that your DA, in your case, doesn't know about the misconduct that the police have committed in your individual case, which was exactly the situation in Obie Anthony's case. That was also the situation in our first civil rights case that we had, Thomas Goldstein, who there was a jailhouse informant who made up a confession by Goldstein, which wasn't true, and he got probation instead of jail for making up the confession, and that was not disclosed to Tom Goldstein or his defense attorney. So that's one type of claim. It's a Brady or Giglio claim. And let's go to the next slide. This is another type of claim. And I alluded to it a moment ago. This is a fabrication of evidence claim. And this can occur with like experts making up test results, or the police either fabricating what the suspect or the defendant said to them, claiming he confessed to the murder when he didn't, or fabricating an eyewitness identification when the eyewitness says, I really can't identify the person, and then they write a report saying he did identify the suspect or the defendant. Or it can be a little more subtle like they kind of fabricate how the lineup was conducted, the photo display, which happened in Noby's case. If they fabricate or make up, like they suggest who committed the crime, which is the defendant, by the way they do the lineup, the photo display. For example, if they subtly kind of tap on the photo of the defendant, or we have a case right now we're looking at potentially where they actually told the eyewitness, you're not leaving this room until you identify someone. That's highly coercive. Or if they tell the person looking at the photo display, like you're supposed to tell the person looking at the photo display, the suspect may be in the photo display or not in the photo display. But instead, what they say to the person is, this is the person who committed this crime is in the six-pack, okay? Because the police, see, the thing is that it's not like the police are necessarily saying, just making up the suspect and just putting anyone in the photo lineup. They think that the defendant committed the crime. So an unethical police person, or a person who's not willing, who thinks that the ends justify the means, are willing to make up evidence to frame someone that they think committed the crime. When the problem is the police don't really know who committed the crime, and they should be open. The problem is a lot of police have what we call tunnel vision. They glom onto, or they kind of get wedded to a particular suspect, and then they do everything they can to convict them instead of what they should be doing, trying to solve the crime. So what happens is, like, there's a couple type of fabrication claims. One is against a scientific expert. Cognitive dissonance. Yes. They think that you did it, and so, or another way of framing it, Ruben, is confirmation bias. They think that they got the right person, so instead of trying to solve the crime, to resolve their dissonance, or to confirm their bias, they end up trying to frame the suspect instead of doing what they should be doing, solving the crime. I mean, that is probably the main thing that happens in most of these wrongful convictions where there's police misconduct. So one type of claim is when there's fabrication of an expert report. Like, you know, there was a scandal where in Massachusetts where they weren't testing the drugs. They were just writing up, because they had such a volume of cases, they made up whether it was cocaine or not, or if it was heroin or not, without even testing it, and say it was heroin, cocaine, and it led to thousands of people being convicted because they're, you know, they have a report that says, oh, it tested positive for cocaine, and so their defense attorney says, hey, they found the drugs on you, it is cocaine, you better take a deal or you're looking at state prison, I can get you probation, right? And instead, it wasn't cocaine, or it wasn't heroin. And, you know, that's one type of claim, where they make up DNA results, or they make up fingerprint results. Or, you know, we had a case involving Bill Richards where they hired an expert odontologist who's a bite mark expert, who made up saying that the victim had a bite mark and that it matched Mr. Richards' teeth, when one, it wasn't a bite mark, two, it didn't match his teeth. And he got exonerated on that basis, and we're dealing with a civil rights case right now. Now, another claim is fabrication of evidence, where defendants use investigative techniques that were so coercive and abusive that they knew or should have known that these techniques would yield false information. An example would be where the police point to the suspect's photo in the photo six-pack. That's a coercive identification technique. Another example would be where, like in the Goldstein case, where they coerce a jailhouse informant confession. The jailhouse informant says that the defendant confessed in jail to him because that's the only way they're going to get out of jail. So that's another type of claim. We call it a fabrication of evidence claim. Next slide, please. The next type of claim is eyewitness identification claims. Often when there's a fabrication of evidence claim or a Brady claim, because you conceal how the lineup was conducted. So that'd be a Brady claim. You fabricate the results of the lineup. That's a fabrication of evidence claim. Then you can also bring an eyewitness identification claim that the way the lineup was conducted was so suggestive, it's not reliable and violates the due process rights of the defendant. And such suggestive procedures could include not telling the witness to only pick a photo from the six-pack if they see the person who committed the crime. Okay, that is, a suggestive to like kind of like they'll often say like, well, pick the person that you think might be the person who committed the crime, and then the person picks someone, and then they write 100% positive ID on the report of the identification, and it wasn't a positive ID at all. And then when the person is about to testify at trial, the police say, well, you did, look at your report, you did make a positive ID, 100%. And they're kind of like scared of the police, and so they take the stand and say, oh yeah, it was 100% positive ID. And then years later, they start to feel bad because they know in their own minds it wasn't 100% positive. And it was a suggestive photo spread ID by the police. And they come back, they talk to the habeas attorney and said, I didn't have a positive ID. You don't know how many cases where people are not sure, but their identification is portrayed as being 100% positive, and it results in a wrongful conviction. Or they fail to tell the person making the identification that the suspect may or may not be in the photo. And this leads the person doing the witness to think, well, that person must be in the photo display, or else they wouldn't be showing it to me. So they pick someone. Or putting together a lineup where the defendant is the only one who looks like the suspect and everyone else looks different. Okay, so those are the types of suggestive photo procedures that can lead to a due process claim for a suggestive photo spread identification. So next slide, please. Another type of claim is a reckless investigation claim. This is more recent, okay? And this is basically saying that where the police are so reckless in their investigation, they violate appropriate police policies and standards, and they act in a manner that's deliberately, they act with disregard to a suspect's constitutional rights. This could be where they coerce or threaten a suspect to falsely confess, or they purposely disregard evidence that's exculpatory, or they destroy potentially exculpatory evidence, or they systematically act in a systematic manner to implicate the defendant in the face of contrary exculpatory evidence. We think that a reckless investigation happened in the Richards case that we're litigating, that the police ignored tire tracks and footprints that wouldn't be the defendant's footprints, or they destroyed them when they did the crime scene investigation, or they ignored sources of potential fingerprint and DNA evidence, and they failed to preserve that. And so then it destroys potentially exculpatory evidence that the defense attorney and defendant could have availed to exonerate them. So reckless investigation is a type of a claim that you can also bring. Now, the next slide, please. The next type of claim is what we call a Youngblood claim, and that's when the police deliberately destroy potential exculpatory evidence. If the police either knowingly destroy exculpatory evidence or knowingly destroy evidence that is potentially exculpatory, that can violate a defendant's due process rights. Okay? Now, under Youngblood, if the government failed to preserve evidence that was potentially useful to the defense, and the government acted in bad faith in failing to preserve that evidence, you have a potential claim. Now, bad faith does not turn necessarily whether the police thought the defendant was guilty. And when I say on the side, whether the defendants, that's the defendants in the civil rights lawsuit. I should have said police there. But as the Youngblood court noted, the police knowledge of the exculpatory value of the evidence at the time it was lost or destroyed is determinative. And whether the destruction of evidence is in accordance with established policy is relevant in determining whether the evidence was destroyed in bad faith. So in the Richards case, there is policies that you're supposed to preserve fingerprint evidence, DNA evidence, footprints or tracks at the crime scene. They failed to preserve it according to policy. We felt that that was an appropriate Youngblood claim in that case.
I have a question right there, Dave, before you go
Sure.
further. Now, question is this, is that do you need to have an offer of proof or showing in respect to that evidence that you're referencing to have been destroyed or lost? Because I'm thinking in my mind, if it's destroyed, or not there, would the court ask, or is there, something, in other words, that we need to show, that need to be shown, that in fact, that this was a piece of evidence, it should have been there, and now it's not? Like, do the court recommend a showing of that?
Well, there are several ways that you can attempt to show that. Like, for example, let's say there's blood all over the crime scene, and let's say that there's a particular piece of evidence, like let's say a piece of clothing from the victim that's destroyed, but okay, so you can't link a third party's DNA to that particular piece of clothing of the victim. But let's say that there's blood at the scene that belonged to a third party suspect, but maybe not on the victim's clothing, or maybe not on the murder weapon. You could point to the blood of the third party suspect somewhere else and say, hey, that blood that was on that murder weapon that was wiped down to prevent DNA, or the suspect victim's clothing that was destroyed. We know that there was third-party suspect DNA somewhere else at the crime scene. It's likely that it would have been there. And the police, according to policy, should have never wiped down the murder weapon, should have never destroyed a piece of the victim's clothing. That's like fundamental police work. If they destroy the victim's clothing, if they wipe down a murder weapon, I think you would have a very good Youngblood claim. Because you could say, we have blood, third-party blood somewhere else. It's likely that the third party's blood would have been on the victim's clothing or on the murder weapon. Interesting, in the Richards case, one of our claims that we're litigating, and it's a very interesting claim, is that they had a policy in their county where they would not call out the coroner's deputy to examine the victim's body right away until after the crime scene was processed. They would not let in the coroner's deputy. So the murder occurred late at night. They waited till the morning to process the scene at the light of day. They processed the scene. And then like 3 hours later, like 10 o'clock, the coroner's deputy shows up. Now, from the time of the night before when the murder occurred to the morning where the coroner's deputy showed up, That's like 12 hours. The body already went through rigor mortis. The coroner's deputy testified at the criminal trial. I couldn't do any assessment to determine time of death because the body had already gone through rigor mortis. It was useless to me. So we said in our civil rights case that that policy in the detectives' knowledge, knowing that time of death was a critical issue because Mr. Richards said that his spouse was already deceased when he returned home from work. And they're saying that they had a police officer who said the blood was fresh at the crime scene. Never mind that he's not an expert and you can tell whether the blood is fresh or not. But they knew that time of death was an issue that night. And the later that the fresher the blood was, the less rigid the body was and that sort of thing, the more they could say that the victim, Richard's wife, had died later at night at a time maybe when Richards returned home after work, whereas Richards was saying that she was dead when he came home. And his defense attorney was trying to say that the victim died hours before Richards returned home from work. That was a live issue. And so we argued that that was a Youngbug claim, that they destroyed exculpatory evidence, time of death evidence, by delaying having the deputy coroner to come out to assess time of death.
Okay, I got it.
So do you understand that? That's so,
Yeah.
I mean, I know that's really particular, that case,
No,
but that's
but
a type of a,
I understand the tweak there because the argument then lies on their, their failure becomes a destruction of that evidence because they
Right.
didn't capture it at the time that it was pertinent to capture it. And because
Exactly.
because they failed to do so, it destroyed that opportunity, and hence any opportunity, in other words, that one would be able to seek to find, evidence of innocence or any of the above. So yeah, I got it.
Yeah, or like also in the Richards case, they said that they only found his footprints and the deceased wife's footprints at the scene, but they trampled over the scene and destroyed footprints at the scene. So we argued they destroyed exculpatory evidence to prove a third party was at the scene.
Ah,
So next slide, please.
okay, thank you for
May
that.
I say something, please?
Sure.
Okay, I've seen you talk about a 6-pack of pictures. I had a one-man lineup, and that was it, nothing else. And I got there, they took me to the police station. I stayed there like 2 hours, and they must have called the girl to come in, and she drew me through a a one-way mirror. And after asking several times for me to repeat, "You sure?" sharp-looking dude several times, then she started screaming, and they arrested me. That's one thing. I don't understand that, but I was charged in a different county, and they acknowledged it. This attorney acknowledged it, and they let me go. Not the district, but the judge acknowledged it. They let me go out of prison, and the district attorney appealed it, and Georgia upheld it, and they put me back in prison again, saying it was okay to put me in prison in the wrong. Because they charged me in the wrong county.
So you're asking about whether do you still have your criminal conviction, sir?
Yes, I do now. Yes.
Yeah, well, you have to get that dismissed or be exonerated before you can pursue civil remedies. But as far as a civil rights lawsuit, that's a potential. You could argue that potentially the show up of the victim was suggestive. That's potentially a claim. And that claim would apply in your habeas as well. Okay?
Question. Oh, that's
okay.
Is it question with that, Dave? And I thank you for that, T, for that right there too, T, because it brings this question to mind, which is this: is there a way through a 42 USC 1983 to receive remedies to be to get exonerated through the civil process? Can you be exonerated through the civil process? Can someone sort of skip the habeas to sue to get out?
No.
Okay.
Only through a habeas. You have to collaterally attack your conviction and get your conviction dismissed and be exonerated before you can file a civil rights lawsuit.
Okay. All right.
Now, another type, most people are arrested by local police, but if let's say you're arrested by an FBI agent, you can file what we call a Bivens lawsuit against the FBI agent or the DEA agent. And basically the rationale under Bivens, although there's not a civil rights statute that applies to federal police officers, the Supreme Court said it would be unfair to allow misconduct against local police be addressed in a civil rights lawsuit, but not be addressed against federal police. So I'm just bringing up that you could bring a lawsuit against federal police as well. We call it a Bivens lawsuit. The same 2-year statute of limitation applies. In fact, we're bringing a lawsuit for Jay Krause in Arizona that is a Bivens suit and a 1983 suit because it was an FBI agent who did comparative bullet lead analysis, which has now been determined to be phony and fake. And the thing that was interesting in that case, he had written an article kind of saying there's problems with comparative bullet lead analysis. Then he testified in Mr. Krause's case that the bullet that killed the victim was indistinguishable from the bullets that that Mr. Krause had on his property, came from the same pack. That's what comparative bullet lead analysis does. It analyzes the chemical properties of bullets to see if there's a match, and then they determined that that analysis was just fake and it's not useful at all. But we're suing the FBI agent, and we're suing him both as an agent of the county under a 1983 action. We're also suing him directly as a federal law enforcement agent under Bivens. So if you've been deprived of your civil rights by a federal police officer, you can sue them. Like, for example, let's say in these Black Lives Matters protests, let's say what was happening in Portland, and remember how there's all these federal police that were sent by Trump there? Let's say one of them shot a protester for no reason. They would have a Bivens lawsuit against that federal agent, okay? So I just wanted to bring that up. It's not so common because most people are wrongfully convicted through the conduct of local police. Now the next slide, please, Gail. We're almost done. I'm sorry. The next, I hope this is useful to all of you, but then, okay. The next type of lawsuit is what we call a Monell lawsuit. This is against the entity. And this is what we prevailed on in Obi's case, a Monell lawsuit. And because Obi said, I want to sue the DA. And I told Obi, well, you can't sue the individual DA because they have absolute immunity. But what we can do is sue them for having a custom or practice of not turning over kind of deals they make with witnesses to testify against defendants, like the John Jones deal. Remember, John Jones made a deal to get probation instead of 13 years in state prison to testify against Obi. But what we found out, there was no system or mechanism within the LA DA's office to ensure that one DA making a deal with the witness, John Jones, doesn't tell the DA prosecuting Obi, which is a separate DA, Obi's DA, that they made a deal with the witness to test, so they would testify against Obi. And Obi's DA argues in closing, this witness has no deal to testify against Obi. So there's a problem with the system. So we sued them under a Monell theory of liability, which says that the plaintiff must prove that the government, the local police, or the DA's office has a deliberate policy, custom, or practice that was a moving force behind the constitutional violation he suffered. Remember, his constitutional violation was caused by the detectives who didn't turn over the John Jones deal, didn't inform the DA prosecuting Obi. But a moving force in that violation was the fact that the DA prosecuting John Jones had no obligation. There was a custom within the DA's office not to make sure that the DA prosecuting Obie knew about that deal John Jones had. So for that reason, and it hardly ever happens, that we successfully sued the DA's office. And there was two things. Now, I've talked a lot about compensation, but one of the things you can also sue, and this is one of the reasons you bring a Monell claim, is to change the policies and practice of either the police or the DA's office. So what we did with the DA, and Obie was willing to because he had settled his case with the police, LAPD, for a substantial sum of money. And he did that first, that with the DA, he was willing to settle for less money if they instituted a policy or a custom or practice that would prevent what happened to him happening to other people. So what we agreed to, and this took months to negotiate and to actually do, they actually created a computerized system in the LA DA's office. So any DA who's now prosecuting a case and they have witnesses can check the database and see if any of their witnesses is being prosecuted by their office and has made a deal to testify in the case that they're prosecuting. Because often there's often a lot of street crime. And some of the witnesses may be in a situation where they have their own charges. And they'll say, well, I'll testify against the defendant, but you have to give me probation on my case. So now, with the system that the DA has now instituted, the criminal defense attorney defending a person where the witness made a deal to testify against them, that defense attorney should know about that deal and be able to point that out to a jury that that witness is testifying because they got a great deal, not because they can identify the witness or that the defendant confessed to them. So Obie was willing to take less money to change the system. And it's amazing, what you can actually do. And I was very proud of Obie that he was very interested in changing the policy of the DA's office and the actual practice. They installed a whole computerized system to input this information. So every DA now knows. And so isn't it better, although maybe it's not necessarily better for me who files civil rights lawsuits, but isn't it better that someone's not wrongfully convicted in the first place and they get a fair trial in the first place? That should be the goal. That's one of the points of filing lawsuits for money damages, is if they have to pay damages or if they have to institute policy changes, that you reform the system so people now being prosecuted, it's a little better for them and they have a little fair trial. So that's what you can do with a Monell lawsuit. You can get money damages or injunctive relief, okay? Next slide, please. Now, and just another example of a Monell claim was, and I described it a moment ago, was in the Richards case where they had a policy not to send out the coroner's deputy right away. So you can't assess time of death, which destroyed potentially exculpatory information, okay? It destroyed the ability of Richards to establish an alibi that his wife had died before he came home from work. So that's also, we frame that as a potential Monell claim against the county by having an informal customer practice of the detectives not calling out the coroner's deputy to assess time of death in a timely manner. So there wouldn't have rigor mortis already set in. So you couldn't determine time and death if you wait till the next day to assess it. So next slide, please. Oh, I gave you Obie's example. That was another example of a Monell claim. Next slide, please. And we're almost done because I know this is probably going a little bit longer than everyone thought. It's 1:30. I'll be done in about 2 minutes. Now, one thing you got to remember are the common defenses that apply in a federal civil rights lawsuit. First, prosecutors have absolute immunity. You can't sue an individual prosecutor for their misconduct in court. They can put up perjured testimony. They can call a witness that knowingly lies. They cannot be sued individually, okay? That's a Supreme Court case, Imbler v. Packman, 1976 case. We challenged that in the US Supreme Court in the Goldstein case. We went all the way up to the US Supreme Court and we lost 9-0. They affirmed Imbler v. Packman. But I think it still should be challenged today because there have been comments, because that is a judicially created immunity. And now, in a weird way, the Supreme Court is going more conservative. They should not want judge-created law. That's what Amy Coney Barrett just testified to. Judges shouldn't create law. Well, they created law when they created the doctrine of absolute immunity to protect prosecutors. It shouldn't apply at all. And people should still continue potentially to challenge him. One day, they might get rid of it, okay? So qualified immunity is another defense. If the defendant violates your constitutional rights, the police violate your constitutional rights, but if it's not clearly established that it was a violation of constitutional law, the police can get what they call qualified immunity. That's one of the hurdles we're facing with reckless investigation, because that's a more recent theory that has come up in the last few years. And there are arguments that it does date back to the 80s or 90s. It's a question whether it dates back early enough so qualified immunity doesn't apply. I think it doesn't apply to reckless investigation, but defense attorneys have argued that it does, okay? So that's an issue, qualified immunity. Now, for example, it's an issue with these cases that have come up recently with sudden death syndrome, or when a baby dies right away and they examine the brain and they determine that it must have been a forceful blow, when actually the scientific evidence is evolving and is showing that it actually could be just from a fall or from something that had nothing to do with use of force, and the science is evolving in that area. Well, it's really hard because that opinion, that forensic opinion about it being someone having to apply force, like the parent killing their child or hitting their child or whatever, caused the death. That was kind of a wedded theory in the 90s. And now all these convictions are being overturned in that area. Habeas are granted. But if the science is debatable at the time that the defendant was prosecuted, it's much more difficult because the defendants can allege qualified immunity. There's arguments around it to say that the science has changed enough to establish that the child abuse expert was reckless or not qualified or didn't do a sufficient examination. So whether the science was debatable or not, they were incompetent and didn't do their job. But that's an area where qualified immunity is an issue that you have to deal with. Next slide. Innocence. One of the things is not only do you have to prove liability, you have to prove that you're innocent, okay? The jury's not going to award you damages if they think that you're guilty, okay? So that comes up in cases. They'll say, so what, the defendant's rights were violated, he was really guilty. And sometimes you have to deal with that in a case. Most of the time, a lot of times it's not an issue, because exonerees by definition, my opinion is that they're innocent, that they didn't commit the crime. And so it's just something that defense attorneys throw out in civil rights lawsuits. But it could apply in certain situations. Let's say there's a Miranda violation, and the defendant's Miranda rights were violated, and the defendant didn't confess. Well, then the defendant tells you when you file your civil rights lawsuit, well, you know, Dave, I really did do the crime. They did coerce me, but I did do the crime. Well, I wouldn't take that case. I'd dismiss it because I really believe in the context of civil rights lawsuits, in the context of exonerees, the people that we should be focusing are the wrongfully convicted, are people that are innocent. And those are the people that deserve compensation. There's more than enough people out there that deserve to have their claims pursued in civil rights. So next slide, final slide, happy slide. OB civil rights remedy, 8.3 million. That was the civil rights settlement. Against the city, he got, I believe it was 895,000 from the county. And I think on the 4,900, you got what, 400,000 or 500,000, something like that. I can't hear you, Obi. You're muted.
Yeah, sorry about that. Yeah, I think it was like 536 on the 4,900.
So Obi is probably one of the very few that has been compensated by the DA, by the police, and by the state. But he deserved it, right? And if you deserve it, you should be compensated because, as I said in the beginning, and I'll just end on this, nothing can compensate you for the time that you spent as an innocent person serving a jail sentence. Not only serving the time, but having the stigma. And when you tell people that you're innocent, they go, oh, that's what everyone in jail says. I mean, there's nothing worse than that. No amount of money can compensate you for the harm that you suffered. But under our system, you know, you can't go up and beat up the police who framed you. You can only sue them and seek justice. And hopefully what we presented today gives you an idea of civil rights lawsuits, civil remedies in the various areas. Hopefully that was helpful. If anyone have anything they want to ask or questions at this time.
I do. Hey, David, what's the main issue? Why is it so difficult for the exonerees to get compensated nowadays? You know, I was told that you know, when the legislators and they changed the laws, because at the beginning they saw so many, you know, it was happening more often. That's when Innocence Project were getting their grants and they were just popping up. They're like, uh-oh, this is, so then they, you know, they changed the laws and make it where like we have to prove the factual innocence, where, okay, you're innocent, but you didn't prove that you're not guilty. Like, and the only way to do that is by actually like catching the person red-handed. The person that really did it. And that's hard when these prosecutors and police officers have this immunity and stuff. It's you know, when they're the ones railroading us. So because, you know, it's just been so hard and frustrating and heartbreaking to see the exonerated community. We just keep coming up short on these compensations and we're trying to move on with our life. And it's just been so hard. And some of us, it's more doable for some of us to get unstuck rather than wait around for these apologies and monies that may or may not happen.
No, it is, you know, it is a very difficult system. And, you know, I mean, what people fail to recognize, at least what I think, is that there's the people who are exonerated, it's like 1 out of 1,000, 1 out of 10,000, the criminal justice system get their murder convictions overturned and they're exonerated. So the people who are evaluating these 4,900 claims, or if it's a civil rights lawsuit, they fail to take that into account, that basically you've already had to prove your innocence to be exonerated, because I don't think any superior court judge or federal court judge worth his or her salt is going to grant a habeas unless they think the person's innocent, okay? But it comes down to money, right? It's like, they don't want to give up money. They work for the attorney, the state of California, if it's a 4,900 claim, they work for the county or the city police, and those civil attorneys, either private or hired by the city attorney's office. Their job is to prevent you guys from being fairly compensated, basically. They're there to keep the money to the city or county, okay? Their thought is, hey, you got exonerated, you're out of custody, you should be happy with that, move on with your life. No, you were wrongfully convicted. You should be fairly compensated. There have been movements, there have been changes in like the 4900 statute, like they changed the law to make it if the Superior Court judge, you file a motion, finds that you're innocent, that's binding on the board. That's helped a lot, okay? They also defined what is the burden of proof. It used to be like you had to prove that it unerringly pointed to innocence. Now they've redefined it as a preponderance of the evidence. But often the problem is, Ruben, as you pointed out, in these 4900 claims, you're trying to prove a negative, right?
Exactly.
You're trying to prove that I didn't do it. How do you prove that you didn't do it? That's what we face with Mr. Soliotas. It's clear. The experts said we were wrong. He didn't do, there's no arson. The evidence didn't support arson. And then they're saying, and there's no DNA at the scene to prove someone else set the fire or caused the fire accidentally or anything. And Soliotas says, I didn't do it. They said, well, your word isn't enough, right? You know, it was enough for the hearing officer, but not enough for the board. So it's like you say, obviously, if you have dispositive DNA, which also helps with the exonerations, if you have dispositive DNA that someone else committed the crime, you'll be compensated. But there has to be, and there's a lot of talk within the Innocence Projects, within people like Ignacio Hernandez, who does a lot of criminal justice bills, and he's on the board of Exonerated Nation. There's movement to try to make that standard easier to prove. But, you know, a lot of it also is you got to make sure that you hire either the habeas attorney or a civil rights attorney who's going to strategize and think through it carefully when they file that 4900 claim. Like in Obi's case, we weren't going to leave it up to the board to decide whether to compensate him. The police still thought he was guilty, even though he was clearly innocent. And we knew that. So we said, let's file the motion with the habeas judge who thought he was innocent. And then that'll be binding on the victim's compensation board. And that was the way to do it. Or you try to negotiate with the attorney general, which we did in John Smith, to convince him that he was innocent. And that worked in his case. But whether it's the 4900 claim or whether it's a civil rights lawsuit, you want to have someone who knows what they're doing, is very strategic and thoughtful of how they're going to pursue your case and how they're going to try to prove your case. And one thing I didn't say is that even though you've been exonerated, the approach that your civil rights attorney should take is to find more evidence of innocence. Like, for example, in Obi's case, the thing that turned that case is when we served a subpoena on a reporter, Miles Corwin, who wrote that book. What was that book, Obi?
Killing Season, Homicides in LA.
What?
It was called Killing Season, Homicides in LA.
This guy wrote a book, and it contained all this gold, this evidence about how the cops framed Obi, right? And we used that evidence. But one thing that was suggested in the book was that one of the detectives and the reporter was on the roof, and they were looking for like evidence, bullets. And I'm saying, wait a second. John Jones is saying the bullets were fired on the street by the suspects, not on the roof. Why are they looking on the roof? And then I'm thinking, and Obi's thinking, maybe John Jones was potentially on the roof, and he fired the shots that killed the victims, not the people on the street. Obi was never there in the first place, but even the people on the street, we were trying to show that the trajectory of the bullets that killed the suspect came from the roof. We got an accident reconstruction expert. And that's what I'm saying is, even if you have a civil rights case, you just don't rely on the habeas. We got an accident reconstruction expert. We went on the roof. We proved that the bullets came from the angle of the roof that killed the victim. That was one. Two, we subpoenaed the reporter to in taking a long shot that he might have bullets from the roof, because the police said they had no bullets from the roof, right? Casings or slugs. Turned out the reporter did. And at his deposition, he had to produce them. And then we had our expert match that up with the bullet casings they retrieved and the bullets they retrieved on the ground next to the victim. And lo and behold, they were consistent. There was a match. Okay? So those bullets that killed the victim were from the roof, not from the ground. So John Jones' cockamamie theory that some people walked up to the victims in their car and killed them was just utterly, excuse my French, bullshit.
Right.
Okay? That turned the case. Wouldn't you say, Obi?
Yeah, it did. I mean, like, and I always, I point to that time because for me, Miles Cohen had evidence at that point over 20-some years that absolutely destroyed the prosecutor's case. And
that was he kept it as a trophy, and it was evidence. How could he think that he could hold on to it? How could the police let him hold on to it? And after that, they settled the case. Okay? So what I'm saying is, if you have a civil rights attorney, he should be reinvestigating the case and talking to the witnesses again. Okay? Because you never know what's going to come up.
This is one thing that kind of made it difficult when I got out, because I got myself out. I was studying the law in solitary confinement. I filed like 5 habeas corpuses in the direct appeal, and my case was like in shambles. And I shopped it around. Nobody wanted it. I talked to Ron, and it was just too much work. It was almost like starting from scratch. It was like trying to get me back out of prison again. And so it's like, where do we start? Just having to sort through everything, like you're saying, just getting someone that knows the strategy on ways to attack. And then, like you're saying, they don't spell it out because, for money reasons, on my opinion, they never actually say he is innocent. They won't say that, to cover their butt. And then even when they had me in LA County for like a week, even threatening to refile some charges, like with Michael, just messing with me. And the LA County didn't want to release me. They're like, this guy was convicted of murder, and we're going to release him. And they're like, we need more proof. Like, what more proof do you need? He's out. They let go of him. But again, they don't say it. He's innocent. Let him out. So they're like, and even in the courts for the lawsuit, they're like, there's nothing that says he did not do it. That they do that on purpose by design to make sure we don't come out and get paid for it.
Well, that's one of the things that anyone who's still litigating their habeas, one of the issues that comes up, it's granted. Then they say, we're going to re-prosecute you. In Obi's case, they didn't. In Thomas Goldstein's case, they did. Okay? He fought the case and won. He got the case dismissed. But that's a real concern. And they'll say to you, and this is something, I say it's up to the exoneree because they have to decide. Sometimes they'll say that if you agree to waive a civil rights lawsuit, will dismiss the criminal case. I think that's wrong and unfair. They should never use that as a way to avoid civil liability, but that's out there. And that's something that anyone who's going through the habeas corpus process, they have to talk to their habeas counsel and decide whether they're going to plead to something. Because if they plead, let's say they plead to time served. If they plead to something, there's no chance of getting compensation either from the state under 4900 or in the civil rights lawsuit. Okay? But obviously they have a huge hammer over your head. You've shown that your conviction was unfair, and now they're turning around and re-prosecuting you. That is really, one of the things that did is that we were contacted by Mr. Goldstein while his criminal case was still going. And I talked to him and he asked me, can I plead guilty to I mean, I don't want to, I didn't do it, but just to get out of jail, they're offering me manslaughter, time served, if I plead to something I didn't do. And I said, one, you have to live with yourself, whether you want to plead guilty to a crime you didn't do. And you need to think about that. Two, it's going to affect whether you have a civil rights lawsuit or not. If you do plead to it, you probably don't have one, but it's up to you. And Mr. Goldstein said, I'm innocent. I'm going to walk out through the front door, not the back door. I'm not going to plead guilty to something I didn't do. But other people have made different choices, right? And I can't necessarily blame them if they're looking at a life sentence at a retrial. You know, so those are very difficult issues that have to be considered. Thomas Goldstein, he was innocent, he made the right choice, and he was compensated. And, you know, everyone has to make their own choices, okay? But he, you know, and Obi made the right choice too. He fought his case all the way. But, you know, there's a lot of good stories, but like you say, there's your story where you weren't compensated. And there's, you know, for everyone who is compensated, I bet you that there's 10 to 100 who are exonerated who aren't compensated. Getting compensated is the exception. But, you know, I just because it's difficult doesn't mean that you shouldn't do it and pursue it, okay? I'm not trying to discourage anyone. I'm encouraging you to do it, but you should consult with the attorney, be advised of all your options, and make a choice there.
Hey David, hey, do you mind? Is it okay if I reach out? Because in case I have some questions, not just about my kids, but I'm doing a law journal right now. I just got hired on a law journal, and this is one of the I was gonna write on this topic because people automatically think, oh well, you know, their conviction got overturned. People think it's automatic we're getting compensated. They don't understand that this is a huge problem, and we're purposely not getting compensated. And so I was going to write on this topic, on this subject, with the whole us not getting compensated, why, the whole history of it, what's, you know, led to it on a federal level, tying it, because if wrongful conviction is such a problem in a progressive liberal state like California, imagine other states where that aren't as progressive. So
well, you'd be surprised. California is a liberal state, but its law enforcement is pretty heavy and can be pretty oppressive. And people, once they get into justice, you know, this is the thing. This is what amazes me. Everyone I ever talked to has been exonerated or wrongfully convicted. And if the word could get out to people who are just going through the system initially, who are charged and they're going through this whole system, is to educate them and say, you can't take anything for granted. Even though you're innocent, don't think you're going to be acquitted. Because the DA filed charges because he thinks you're guilty. The police arrested you because they think you're guilty. So they're going to do everything, as we said, cognitive dissonance, confirmation bias. They're not necessarily interested in justice, but because of their biases are interested in getting a conviction. And so you need to make sure that you don't take anything for granted at any stage of this whole process. And the system, unfortunately, has been rigged against poor people, minorities, people of color for years. It's always been that way. Why do you think minorities are more the victims of excessive force, right? Why do you think that they're wrongfully convicted at a higher rate? Why do prosecutors try to keep minorities off of juries, right? I mean, you know, you have to, at every step of the way, own your own case. That's one thing I would say. You should own your situation, own your own case, and take proactive steps to consult with attorneys, to make sure you're not missing time deadlines and that sort of thing. And you know, one thing is that you know, you like, oh, but you're the exception of the rule. You got someone interested in your habeas, right? How many people are sitting in jail who are wrongfully convicted for crimes, and they're serving their time, and no one files a habeas for them, and they get no justice?
Right.
I mean, there's a lot of people out there who suffered that way.
And I
And
seen too that it's a young lady on here, Amanda, Miss Amanda Village.
Villegas,
Yeah, Village. She has a question too as well.
sure. Can you unmute yourself, Amanda? Okay.
Yeah, sorry. Can you guys hear me?
Yeah.
Yes.
Okay, sorry. I'm at work right now, but I just have two questions. We're actually in the middle of our civil lawsuit for my husband's exoneration. His attorneys are Levy and Levy. I think they're in Chicago, but we live in Texas. But I wanted,
they're very reputable attorneys. They're good attorneys.
yeah, I've heard great things about them. I'm not really well versed on civil lawsuits, so I wanted to know, we just got a new district attorney for our city, and she's a huge supporter of my husband. So does she have any kind of power to help with the process, you know, compensation and all that? Or
where are you in
does
the process? Was your husband just released?
No, he was exonerated. He actually was offered the Alford plea in 2018, but he refused it. He decided to go to trial, and he was found not guilty in 2018.
Congratulations. Congratulations.
Yes.
So when was he found not guilty? How long ago?
2018, October, 2 years ago.
And you filed a civil rights lawsuit, right?
Well, yeah, we filed the lawsuit maybe 2 years before he was exonerated. So it's kind of been in the process. They were just kind of waiting for this trial to see what the outcome was. But
Okay.
I just want to know how powerful the new DA could be as an asset in our.
Which county is this, Amanda?
This is El Paso, Texas.
So this is Texas.
Yes.
You know, I think and you're trying to get the state compensation or civil rights compensation in 1983 lawsuit, or both?
I think it's both, actually.
Okay. I really think it carries weight if the DA thinks that your husband is innocent. I think that
Okay.
carries weight with the civil attorneys representing the city or county in Texas. And you should talk to the Levy and Levy attorneys and say, how can we potentially get the city attorney or the attorneys representing the city or county to
Mhm.
talk to the DA about my husband's case. So maybe if they believe in my husband's innocence, maybe they're willing to settle the case.
Right.
Oh, okay. Okay, that's good. And then is it also, is it gonna look good on his case that he decided to not take the Alford plea that was offered to him, and he went to trial instead? Is that something we should push to bring in to the civil lawsuit, or no?
Oh yeah, that is very relevant evidence to prove his innocence, that he wouldn't even take a plea
Mhm.
in order to show that he was innocent. I
Yeah.
think that's very powerful evidence. I think that'll carry some weight with the defense attorneys
Okay.
in the case.
Sounds good.
That's really good evidence.
Yeah.
Well, I wish you had talked to our firm where you went with them. I'd be interested in your case.
Well, I follow
Anyway.
I follow Obi and Denise on Facebook, so they're
Yeah.
very inspiring. I've learned a lot from watching them.
Yes,
No,
yes.
I'm just kidding. I'm just kidding. Amanda, I'm just kidding about that. You got really good attorneys.
Amanda.
You got really good attorneys, so you're in good hands. And I
Awesome.
wish you and your husband best of luck in your situation. But it is a long
Thank
road,
you.
right?
Yeah, it's been a few years. I know it takes a lot longer than what we've been waiting, so we'll be patient. It is hard. I listened to Ruben and the struggles that you guys have waiting for this compensation to just move on with your lives, you know. My husband spent 19 years in prison, and we live in a 2-bedroom, 1-bath house, and we're a family of 5. So I mean, we know the struggle, and we'll sit patiently and wait. That's all we have is time, right?
Yeah.
Right. Well, I always tell people, it's hard to move on with your lives when you're faced with a situation when there's something unresolved, right?
Mhm.
It's something unresolved for your husband. And
Right.
I would also suggest that he reach out to OB and participate in a convening, and also
Okay.
all the mental health and other services that Exonerated Nation provides, because that's part of it too. It's the PTSD and the trauma that have been
Yeah.
imposed on innocent people serving time in jail. And that's something that
Mhm.
OB and Exonerated Nation are very helpful with. And that's part of it. It's not just being financially compensated, but
That's
you have to
Yeah.
move on and try to work like you're doing and try to make the most of your lives. But it's not just like, oh, why don't you just move on? It is very traumatic, and you do have to deal with these unresolved, not only mental feelings, but the unresolved, compensation issues that you're dealing with.
Yeah.
Yeah.
And I think this too,
And I,
Amanda, is that, realizing, and I say this to almost all of my brothers and sisters who are exonerated, who is going through this process, or in the middle of the process, or just beginning in the process. Either it's, the 4,900, we're just trying to get compensated by the state, or, a civil complaint, which we were talking about here, the U.S. 1983s. And that's this statement here, is that your worth and your husband's self-worth is way more than what they can ever give you. So do not ever, it's not about waiting, because, say when we're waiting for this, and, we have time. But nevertheless, I
right.
say this, is that with that time, is to do the things that that's necessary to be done, so that if, I always call it a pie in the sky. If the pie falls and lands on you, great. If it never falls, you've done the necessary things in the middle of that, in other words, to establish yourself. Because, after being compensated, after going, took 5 years to go through that process, it took us, and then getting to the other side of that, what I realize and understand now is that the fight is still not over, even after compensation, because there's so many different things that comes along with that bundle of being compensated. And for me, I don't know whether, you may have heard me say it before or not, but I say that, compensation sometimes can become a burden because of the other attached issue that comes along with it. So everyone knows that your husband did 19 years. Everybody, family, friends, and all of the above. And everyone sees the process. And that in itself should be a sort of a peek into the window of just the presumptions of what they may have in respect to that. And so I'm always about affirming the person and affirming you to have your feet on the ground, your solid. So irrespective of whatever that is, that compensation or not, that that your success has happened each and every day anyway. You understand what I'm saying?
Yeah. So don't just rely on that money.
Yeah,
Like, don't just wait and rely on that money.
Yeah, because it can happen, and in
And it
most
might not.
cases that it will happen. But I'm always in that type of place in my mind. Is like, hey, look, okay, like, let's say that it doesn't. We need to do what's necessary now. In other words, so that compensation can be an addition to our.
Yeah, that's what my husband said. He's working for a law firm now for a defense
Nice.
attorney, and he's applying. He just applied to college because he wants to become an attorney himself. So he's like, we're not going to rely on that money, like you're saying. He's like, that's going to be a cherry on the top when I'm already established.
That's what it's about, right there.
That's good.
Hey, Amanda. And also, just speaking on what Obi was talking about, because I didn't allow myself to get stuck waiting for this money, I got into school. My girlfriend's like, if you get straight A's, they'll pay you to go to school. I started going to school, getting straight A's. All of a sudden, now I'm getting $80,000 a year just to go to school. And I put myself in a position. I'm applying to law schools right now. I put myself in a position to take back everything they owe me times 1,000,000 because I wasn't waiting. Now, when that comes, it's going to be nice. But at the same time, you know, we are justice. We make our own justice. It's what we choose to do with it, you know? So,
Yeah.
yeah.
Nice. Thanks,
Not
guys.
just stepping in
Gail,
too.
you had a question. Do you have any idea about the percentage of California exonerees who are eligible for compensation under 4900 and who have their cases expunged under 851.8? I have no idea. I don't know who would know. Maybe NCIP. I don't know who keeps statistics on that.
Yeah, I was just curious, even knowing the, you know, do all people once they're released do they understand that they're eligible for example, the expungement under 851 and, you know, the automatic compensation under 4900. Is that something widely known?
Yeah, well, yeah. Let me, if I can dive in there in regards to the 4900, I think it's just what you just said right there, is that the presumption of the 4900 that it is automatic, right? That somehow or another that the statute itself makes possible the opportunity for individuals to receive that. But there is where we fight. That's what we're fighting at, is in that piece right there, because in that piece right there, we have to relitigate. And what we're trying to do in respect to that is to kill that litigation, to say that the judge's finding of exoneration, letting you out on OR and all of the above, and the district attorney not refiling is substantial enough to, in other words, to be able to get past that hurdle. But in respect to, like, and, you know, for the 8.5 and the 851 point, the 851, I can tell you off the top of my experience in dealing with the exonerees, no, they do not.
They don't. I mean, in the same, it just listening to Dave, and I'm so glad you walked through all of the legislation, including Obi's law. Just out of curiosity, I just remember Xavion talking about how it was still difficult to just get the license, you know, to be able to actually access some of those services, and I was just curious. So, yeah, what percentage of people even get a chance to take advantage of all this legislation that's already been that's in place? Now, I'm not even talking about the new legislation of in 2020 with the housing, because we know what's happening with the new ones, but with the old legislation.
Right. 672, 1050. Who's been getting and who hasn't. And again, you know, I fall back with Dave in respect to that is really is the Innocence Projects. In other words, that would have that sort of kind of click of number, because they are aware of how the person was exonerated. Say, for instance, just yesterday, day before yesterday, Paige Katney got in contact with me about one of their recent exonerees, Bob, who just recently that they just stopped, the district attorney and them is no longer going to file any charges. They, you know, that's part of it is over, and he has his full exoneration. And so, you know, just thinking about that part of the people that becomes aware, how we become aware is that way. That's how I become aware. That's how the organization becomes aware. Like, because they say, well, this person right here is out, or we see in the news that this person got out and they have their factual finding of innocence. I don't know, you know, if there will be a number, because the CDCR has to keep that number, but not the number of who's eligible, who isn't, but exactly how many individuals who walked out of their door up under that exoneration, though. And then I think we can purge from there to see who, you know, who is eligible, who isn't eligible, because a lot of people don't automatically become eligible for those things because of how they are exonerated. So.
And with the expungement, is that you have to utilize an attorney for that? Is that correct?
Well, you could do it pro per, but I think it'd be very difficult.
Yeah.
You should have legal assistance to help you, either the habeas attorney that got you exonerated, or your civil rights attorney,
Right.
or another attorney, because it's not the 851.8 is not automatic. You have to prove your innocence again to get your arrest records destroyed. And that's a hard thing. They don't like to destroy arrest records, okay? It's a very hard process.
Yeah, and so it falls back on the exonerees to.
Yeah.
to have contacts
To have
or
contact
not
and
contacts or
actually-
information.
yeah.
Well, that's one of the good things about Exonerated Nation or other innocence projects who have the contacts that can hopefully get you in touch with people that can help you.
Mhm.
But it's a process that's filled with landmines. You just have to be assertive and talk to people and try to figure out what's the best way to proceed in your individual situation.
Correct. I agree.
Is
I got
there
one
any
more
other
question
questions?
about that 4,900. So they changed it to 10 years now, huh?
Statute of limitations, yes.
And is that retroactive, or is that just from?
I don't know if it's retroactive.
Okay, because I know quite a few exonerators have problems with them, and as far as with the time limits and but not
It
everything's filed.
may apply to the date that it was extended, that you had to be exonerated after that, but I don't know the answer to that question. But they should find that out.
I can get.
I wouldn't say.
I can find out the answer to that.
I wouldn't not do it. I would pursue it.
Yeah, I
If
did.
you file a claim, they'll tell you whether it's retroactive or not.
Yeah, I did, but the attorney that was willing to take my case pro bono, he took it, but then he got suspended and disbarred, and I didn't even know about it until later.
Oh, wow.
Yeah, he really messed me up, and so now I'm like trying to put the pieces back. He filed it in time, but then there was some time restrictions, so I'm trying to like put it together so Adam and Paula and them could look at it and everything. But still, I mean, it would be, if they extended it, I'll just refile it again, be done with it, get back in there. I was just curious about that.
Well, I know we sort of extended ourselves a little past the time, in other words, that we have allowed it out. But nevertheless, I definitely want to tell you, Dave, I definitely appreciate you for